Typically, when a state legislative body passes a new law, it only affects people who live and work within its borders. But every once in a while, a state law has effects felt far outside its boundaries. Such laws often come from one state, California. After all, California is home to nearly 40 million people and is one of the largest economies in the world. So would it surprise you to know that a new law from the Golden State could have far-reaching effects on owner-operator truckers across the nation? Welcome to another edition of the Eyes on the Road podcast, sponsored by PrePass Safety Alliance, the provider of PrePass way station bypass and electronic toll payment services. Online at prepass.com. I'm Evan Lockridge. Back in 2019, controversial legislation was passed and signed into law in California. The measure, known as Assembly Bill 5, requires many companies that hire independent contractors to reclassify them as employees. For trucking, that means many owner-operators in the state can no longer be classified as independent contractors. However, enforcement of the law was on hold until this past summer, when the U.S. Supreme Court refused to hear a challenge to the law. And since AB 5's passage in 2019, there's been a slowly increasing move to apply the same law on the federal level, with passage of a similar measure by Congress. So what does it mean when it comes to the future of owner-operators, especially leased owner-operators? Joining me is Chris Shimoda, Senior Vice President of Government Affairs at the California Trucking Association, which has been waging a battle against AB 5. Chris, welcome to Eyes on the Road.
Absolutely. Thanks for having me, Evan.
Well, to get things underway, can you give us an overview of what AB 5 does in California and how it works?
Certainly. So AB 5 is a law that was passed in 2019 that has to do with the state's worker classification test to determine who is an employee versus an independent contractor of the hiring entity. And for decades before the law was adopted, there was a common law standard known as the Borrello test, which was primarily about the right of an employer to direct and control the work of an independent contractor. And then there were several other factors that were weighted evenly in determining whether or not that worker was in fact an employee. And so that was the law of the land for more than 30 years in the state of California. And during that time, owner-operator independent contractors in the trucking industry were allowed to operate under those set of rules. You know, there were determinations from time to time that an employer overstepped their bounds on that old standard. Independent contractor was in fact an employee, but the cases went roughly 50-50 in favor of independent contractor classification. And so in 2019, in response to a California Supreme Court case known as Dynamics, the state of California legislator at the time, Assemblymember Lorena Gonzalez, introduced AB 5, following up on that court case to introduce a different worker classification test that is sometimes known as an ABC test, which really just uses three factors to determine whether or not a worker is in fact an independent contractor. There is first prong, which is the right to direct and control the worker, same as the old standard. The third prong has to do with whether or not the independent contractor is in an independently established business. The second prong, or the B prong as it's sometimes called, is really where many owner-operators in trucking will run into problems. This is the independent contractor must work outside the usual course of business of the hiring entity. And that, for example, in the Dynamics California Supreme Court case, the example given was a plumber coming to fix the toilets at a law firm, or other examples that have been used is an electrician coming to a retail storefront to install a new line. And so that particular prong of the test was always identified as being the most problematic, given that an owner-operator in trucking really could never be considered an independent contractor since they were working in the usual course of business of many different types of companies that they offer services to. And so That is really the genesis of where the conflict between trucking and AB5 started, is this B prong.
Now, the California Trucking Association challenged AB 5 soon after it was signed into law in 2019. The case wound itself through the courts, with the U.S. Supreme Court refusing to hear the case this past summer, allowing AB 5 to take effect soon after. Why does CTA believe AB 5 should be overturned, and is there a next step in the litigation process?
We continue to argue that AB 5 is preempted by federal law. Primarily among those laws is the F4A, prices, routes, and service preemption, that is part of the Motor Carrier Act at the federal level. And that continues to be our position, and primarily, let's put it this way, is that owner operators have been part of this industry for decades, even pre-deregulation, will continue to be part of the industry moving forward. And a law like AB 5 just completely frustrates the ability of blue collar entrepreneurs to go out there with, used truck prices being what they are today, less minimal of an investment than it used to be. But investing in a truck, going out there and booking freight and starting their own small businesses, that has always been a core of the industry. We have several past presidents of our association that started their career with one truck as an owner operator, which then they grew into sizable operations. And that is really, I'd go so far as to say, the American dream with respect to the way that the industry works, that you're going to go out there with one truck and build up into a sizable fleet. And so we continue to make the arguments, from a procedural standpoint. Where we are right now is, since we went up on this preliminary injunction through the process, the case was never actually heard on the merits at the district court level. And so we're just being returned back to the district court to continue that process, where the issues will be fully briefed. Evidence will be provided into the proceedings, and the judge will decide on a more complete record, once we actually get to that phase.
Now, backers of AB 5 contend the law was necessary because of what they feel are workers being wrongly classified as independent contractors, including truckers, when they're treated no differently than employees, but without the benefits that employees receive. What is CTA's reaction to this?
The old standard, I think had a weighting of various factors, but nobody would have ever argued that the standard prior to AB 5 just completely prohibited the 70,000 owner operators in the state of California from choosing to work as owner operators. Like I said, the cases sometimes came out in favor of independent contractor classification, other times came out in favor of employee classification. The real issue is, if you are concerned about driver misclassification, I think many in the industry share that concern. But to impose a test that basically makes it impossible for that blue collar entrepreneur to go out there with their own truck, booking their own freight, working with motor carriers and brokers to supplement their living, and then ultimately building out their fleet into a more sizable operation. We've completely thrown the baby out with the bathwater, so to speak. Concerns about misclassification basically just turned into a total prohibition on owner operators working in the state. Unless they, decide, hey, I want to go out and be an employee driver, enter into what's known as the two-check system, where you technically are an employee of the hiring entity, but bringing your own equipment. But the days of owner operators coming to the state of California and working as owner operators, are threatened due to the law.
Do you believe that AB 5 could threaten owner-operators on a national level, especially if there is a move in Congress to pass similar legislation?
So, let's just talk about AB 5 for a second. And this is an open question with regards to anybody coming in from out of state, working in the state of California. It's clear that if you are a California resident working for a California domiciled fleet, the law is going to apply. What I think is less clear is if you are a out-of-state owner-operator, either working for a fleet that is located inside or outside of California, but you're coming into the state of California doing work for the majority of any given pay period, there is an open question about whether or not that worker classification test is going to apply. The general feeling from counsel that we've talked to is that regardless of where the owner-operator is domiciled or the fleet, if a majority of a pay period is being done in the state of California, there is at least a possibility of the application of that worker classification test. Now, at the federal level, there are ongoing discussions in Congress about what's known as the PRO Act, which would seek to apply that ABC test specifically in the context of, as I understand it, the National Labor Relations Act, right to collectively bargain and organize. We're really focused on trying to make sure that we speak to legislators, other key stakeholders on, our issues with AB5. We've got, again, 70,000 owner-operators whose livelihoods are threatened as we speak, who are needing to make some pretty tough decisions, either accept an employee driver position they may not want, leave the state, in any event, having their livelihood severely impacted. That is really our near-term concern, is trying to make sure that the law is clear with respect to how owner-operators and fleets are supposed to work with one another under this new law.
AB5 went into effect this past summer. What's been the biggest effect so far, both inside and outside of California?
Really what we're hearing is fleets are, to the extent that they did not already back in, 2019 when the law was originally passed, they're all scrutinizing their operations and making sure that they try to become compliant with the law. In many cases, that means having discussions with owner-operators to say, look, the options here are become an employee driver, have company driver positions open, or if you want to continue being an owner-operator, at a minimum, we can no longer have that relationship. You can no longer have any sort of business relationship with us as a motor carrier. Many people are moving towards pure brokerage models. We're seeing some of that. There's definitely anecdotes about owner-operators either calling it quits. I think it's a mix of 85 or moving to other states. I do know that there is some percentage of folks that is the decision that's being made. But, I think we're going to really start seeing the fallout over the next year or so as some of the alternative models start being challenged in court, as enforcement starts becoming more clear as far as what stance the state is going to take and, what form and fashion that's going to come. This is going to be kind of a slow moving process to unwind, what has actually transpired over this last month with that injunction being lifted.
Chris Shimoda, Senior VP of Government Affairs at the California Trucking Association. You can find him and CTA online at caltrux, caltrux.org. Chris, thanks so much.
Great. Thank you, Evan.
And thank you for listening to the Eyes on the Road podcast, sponsored by PrePass Safety Alliance. Please remember to visit the PrePass website at prepass.com, where you can read about trucking industry issues in the PrePass blog, as well as in the resource library. Also, you can keep up with PrePass by visiting us on Facebook, Twitter, Instagram, LinkedIn, and YouTube. I'm Evan Lockridge, and until next time, remember to keep your eyes on the road.